What's up, folks? Welcome to my channel Germain Talks, and I hope you're doing safe and excellent as always. Today, I have come up with this topic of parent company guarantee and how does it relate in day to day contract management. So, stay tuned till the end of the video, and I hope you'll find it interesting. In case if you have shortage of time, you can skip. Towards the end, I'll give the main takeaway of this video. So, let's get started. Well, at a definition level, parent company guarantee is actually a document which is issued by the parent company towards the financial or the operational performance of its subsidiary in the contract, and it is always issued to the client who is paying for the services. Well, at any given point of time, there are two poles on which the decision is taken, and whether the parent will go ahead or child will go ahead, or whether we'll issue a parent-child guarantee or will not issue a parent-child guarantee, or who will sign the contract. The two poles are the business and financial pole, and the second one is the legal pole. Well, in the business side of things, it's just a way of contracting that the parent is always projected as the main performing party. Like, for example, if ONGC, Oil and Natural Gas Commission, a big state-owned upstream oil exploration company in India, if it wants to bid for an oil field in Venezuela, it will always go ahead as ONGC is pitching for the oil exploration work. But is ONGC going to sign the project in Venezuela? Probably not. Or most of the Indian IT companies, whenever they are bidding for multi-billion-dollar or multi-million-dollar contracts, they often get confronted with this choice or with this problem: who will sign this document? But at the time of bidding, it's always projected at this company, the parent. $15 billion corporation will sign this contract. So this is how the whole discussion progresses on the financial side. But many things have to be considered, like what is the bid size. Many times it so happens that the client mandates that in order to bid for this project, the company has to be this big. In case if it's not a mandate, then a child can go ahead and sign the contract. Sometimes there are tax implications. So in the ONGC example, what if ONGC goes ahead and sign the contract in Venezuela? Maybe some Venezuelan tax laws may bring the whole parent company into taxation related matters, which the company is earning revenue all across the world, but it's now subject to Venezuela taxation. So in that situation, it's always prudent to bring forward the child company. Then there are certain government needs. So maybe under like Make in India policy, if there is a Canadian drug manufacturer, if it wants to sign up a contract with some company in India, so it cannot go ahead and sign it because it has to do Make in India, it has to do local production. So in that situation, the entity has to be locally present in India. So then the child will go ahead and sign the contract. Of course, the government or whatever the company would always want the child's performance to be guaranteed in some form or the other by the parent corporation. Okay, so this is the financial and business point of things. Now, also I like to add that there is a bit of callousness, I would say, or a bit of misunderstanding in understanding these terms, the parent-child guarantee within the business community, because it often said that, oh, you know what, I already have the contract and I already have the guarantee, and I can go ahead and terminate it and ask the parent to come and render the performance, or pay me the money, or I'll do whatever I want. I'm super king. But no, that's not the case, because the guarantee is always valid till the time the contract is valid, or till the time the deliverables in the contract are only in question or in dispute of malperformance, misperformance, or non-performance. So if the contract is for making chairs, and if the client is asking to make tables, and the vendor is not able to do so, it cannot go ahead and invoke any guarantee unless and until it's explicitly authorized by the guarantee issuing company. So much needs to be read in this context, that a guarantee is only valid till the time the contract is valid. Upon termination, or upon any kind of extra contractual items, the guarantee is ab initio, null and void in certain cases at extreme. Okay, now coming to the legal side of things. Now, within the legal side, how wouldn't it be good if all the subsidiary companies can go ahead and sign, or wouldn't it be good if the parent couldn't go ahead and sign? Well, there are legal dimensions to it. If in case the subsidiary is unfortunately gets embroiled into any kind of contract dispute, and it further graduates up to at a litigation level, the parent will always want to keep an arm's length distance and to cut away, because in case of any liability claims and indemnity damages and things like that, it's always prudent for the parent to be cut loose. But from the client point of view, it always wants to, choke the throat of the main parent body. Well, in the legal sense, there is also one thing important to mention, that there is always financial and performance guarantee coupled with bonds. Now, the performance guarantee is only valid for the performance. If the subsidiary is unable to perform the contract, then the parent can be called in as a step-in. But here is the thing, that in case of any proprietary, proprietary product, or any product which is unique in the world, which is made only by this manufacturer, then in that case, the performance guarantee is like almost as good as the paper on which it's printed, because there is no one in the world who can deliver that service or make this particular product. Well, in those situations, there is always money which you can take and walk away. So how to take the money? Money is, in this situation, can be financial guarantee or a bond. Now, bond is something which survives the contract termination. In case, like I said, if the contract is terminated, even because bond is always held by a financial institution like a bank, so the aggrieved client can always invoke the bond and take the money and walk away. Certain cases, there are also within the contract there is a provision of indemnities, but who is more powerful? Bond is always powerful, because it's held by a separate institution, and it has power to even survive the termination of the contract. Okay, so these are the performance and the financial and bonds. And the last thing which I wanted to say in terms of the key takeaway is always to be extremely prudent of the fact that to the clients, that are you getting something which is looking like a guarantee but not a guarantee, or you're saying that, you know what, the parent company's VP is my golf buddy, it's okay, I'll take care of that. No. Or you may say, oh, you know what, the parent company's VP just wrote me a great letter of support, great letter of comfort, and guaranteeing the performance. So please stay away from all those look-alike documents, because guarantees are very traditional, very old fashioned documents which have to be very meticulously designed, and so that it serves the purpose for which it has been made for. Well, that'll be all, and I hope you liked a warm up of this wonderful concept of guarantees in a particular contract. And if you do liked it, please like, share, and comment my video, and I hope to see you soon in another video. Thank you very much.